Welcome to Renters' Rights Radio.
Welcome back to Renters' Rights Radio with attorney Debi Rumph, founder of the law offices of Debi Rumph. Debi focuses on Florida tenant law and works with renters across the state to help them understand their rights, navigate lease disputes, and level the playing field when landlords push the limits. I'm Evan Mack, and today we're answering one of the most stressful questions college students can face. My roommate stopped paying rent. Am I actually responsible for their portion? Ms. Debi, welcome back.
Thank you, Evan.
So, Ms. Debi, from a legal standpoint, what makes college student housing leases structurally different from a typical residential lease?
So I want to be clear that they can be the same under certain circumstances. So if we have a single student, they enter into a lease and it's just them in the rental, that may typically look like the lease agreements that we see on a day-to-day basis, something that their parents would sign. The complexity arises when we enter roommates into the equation. I like to call them the joint roommate leases. Now, those joint roommate leases, the traditional roommate leases, are extremely risky and they could be very unfair. As a result, over the past 25 years or so, a new type of roommate lease has evolved, and I like to call that the single roommate lease. Now, it has its own pros and cons, but it is a lot less risky than the traditional joint roommate lease.
So if if you were a college student and enter into a roommate living arrangement, what would you personally prefer, because the joint or that single?
I personally would prefer the single roommate lease. It's a lot less risky. It is much more fair to individual students and tenants. So that's definitely the one that I would highly recommend that students navigate toward.
So, Ms. Debi, let's discuss the two types of college roommate arrangements. What are they actually?
Okay. So as I indicated, there is the traditional joint roommate lease. That is what most people are used to hearing about because those types of leases have been around forever, right? Since common law. And under the joint traditional lease, if one tenant misses their rent payment or if one tenant breaks the rule, they can cause all of the tenants to be evicted, even if they paid their rent, even if they're following the rules. So that is the traditional roommate lease. Now, under the single roommate lease, each tenant is held accountable for their own actions. So if a tenant pays their rent, there's no risk of them getting evicted. If that tenant follows the rules, there's no risk of that tenant being evicted. So those are the two different structures that exist for roommates.
So if it was up to you, you would prefer the single roommate lease as opposed to the joint roommate lease?
Absolutely, without a doubt.
So what type of agreement gives the LL the most leverage?
So the LL is the landlord, right? And so the landlord is going to prefer, from a debt collection standpoint, the traditional roommate lease. And the reason they're going to prefer that is because they could force everybody into an eviction if that money is not paid by someone. So landlords tend to prefer the traditional roommate lease over the single roommate lease.
Mm. So let's talk about joint and several liability. What does that actually mean inside a student lease?
Okay. Well, it depends. And it's going to depend on what type of lease the student signed. If the student signed a single roommate lease, which is the new type of lease that has evolved over the past 25 years, there should be no joint and several liability. And I'm going to say should because if it's a true single roommate lease, the tenant is only responsible for their actions, for their rent. However, if the tenant signed the traditional joint roommate lease, that means the tenant is on the hook for all of the rent. It doesn't matter if they paid their share, all of the rent must be paid. All of the tenants owe all of the rent. They could go after one or all of the tenants for the rent, get a judgment, and cause an eviction. So joint and several liability operates in the traditional joint roommate lease, but not in the single roommate leases.
So when one student stops paying their portion of the rent, does joint and several liability apply?
It depends. It depends if the student signed a joint traditional roommate lease. And if they did, yes, it would apply. If they signed a true single roommate lease, it would not apply.
Mm. So does the landlord have to, pursue the non-paying roommate first, or can they legally demand the full rent from the remaining tenants?
The landlord has no obligation to go after the offended tenant. The landlord would generally, in my experience, working on these types of cases, the landlord says, I don't even want to know. Don't tell me who did not pay their share. We want all of our rent. We're not going to get involved in the dispute between the tenants. Either have all of our rent or the eviction will be filed. And so, no, they have no obligation. Most landlords do not get involved on the details of who didn't pay and when they paid or any of that. They have no obligation and they move forward with the eviction, which provides them with the leverage to collect the debt. So no, they don't have an obligation to go after the offended tenant only.
Hmm. So how often are students surprised when they find out this is how leases work?
Tenants who sign the traditional roommate lease are surprised all the time. It's not written in the lease. There is no lease provisions that are written in the lease traditionally that puts a tenant on notice that if you pay your share and your roommate doesn't pay their share, I can evict everybody. I've not seen a lease that says that, nor does the law require the lease to say that. So tenant students are surprised by this all the time. But I'll tell you who is even more surprised than the students. And that's generally the parents who co-sign this traditional joint roommate lease. They have no idea that they're on the hook for all of the rent, that their credit could be damaged because one tenant has not paid their rent. And they're generally surprised because they're not entitled to notice beforehand before the credit's impacted or the evictions are filed. So students are surprised all the time, but I find that most of the surprise come from the parents in this situation who have co-signed the lease.
Mm. How can this structure create tension or financial strain between roommates, even if one person is clearly at fault?
So if we take a moment to think about this, right? One tenant, whether that tenant has broken the rules, whether that tenant has not paid their rent, they're impacting all the other tenants in that lease or in that apartment or rental property. So you have tenants who are getting evicted, their credits are being damaged, all by things that they have no control over. That in and of itself will create a lot of tension, right? I mean, you're causing damage to my credit because of your actions. That's going to cause tension. But even what will cause even more tension is the only solution in those types of situations once you enter into one of those types of leases is to pay the other rent, to pay the rent that the roommate is not paying. As you can imagine, that creates tension. It's a financial strain. Everybody's coming up with additional money to pay the rent. And what can make it even more stressful is if the tenant who couldn't pay, if they stay and then their rents are being paid. And so that creates even more emotional tension within the rental home. So it creates an extreme amount of tension between tenants when people are being impacted in a huge way, all by things that they have no control over.
So Ms. Debbie, if a dispute escalates, though, what legal, remedies does the landlord typically have, and how quickly can the situation move towards eviction?
So you said it. That's the remedy that the landlord has is eviction. Okay. Especially I see this especially in the traditional joint roommate situations. The landlord is quick to go to the remedy of eviction because that's how you mobilize everybody else to come up with that additional rent money so that the landlord is made whole. It also depends on the type or the reason why the landlord wants to evict or the reason underlying the eviction. If it's for non-payment of rent, the landlord must serve all the tenants with a 3-day notice, giving all the tenants 3 days to come up with that additional rent. And if that rent money does not materialize, then the landlord can start the eviction process. However, if the reason for the eviction is a rule violation, it could be either immediate with no additional notice, or it will be a 7-day notice. The amount of time that will be given will depend on the type of violation. Okay. Now, I want to note, I'm not saying that a landlord could have all the tenants out in 3 days, and I'm not saying that a landlord can have all of the tenants out in 7 days, but that is what is required of the landlord to give the tenants an opportunity to make things right before the eviction process is started.
Mm. So the student tenants usually understand that they can be held responsible for the full lease amount, or is it something, kind of buried in the agreement?
Unfortunately, Evan, it's not even buried in the agreement.
Wow.
I've never read a lease that explained this outright
Wow.
to any tenant. Unfortunately, it is a contract principle, and it's a principle that is provided in the statutes, Florida statutes. So most tenants are surprised because I don't care how carefully you read that lease, there's no provision telling you that this can happen to you. Unfortunately, it takes law school to teach you the principles of contract law and how to read and interpret statutes to know that this is even a possibility. So I don't have to say it catches a lot of students off guard, and it certainly catches a lot of parents off guard, even other professionals. You have professionals who have leased all their lives and they have no idea that this was a possibility.
Hmm. If the lease never expressly says this, how should the student or parent center, like, how should they know this? Where does knowledge come from?
Unfortunately, it comes from professionals who are in this space. It comes from lawyers who know contract law. It comes from professionals who have read and understood the statutes. And it comes from people telling their stories. And so, unfortunately, that's the only way that this information can be disseminated because it's not written in the lease at all.
So with that being said, before signing, what specific language should students and parents look for to understand the scope of this joint liability?
So there are two things that I generally look for. When I have a roommate case, that's the first thing I want to understand. Am I dealing with a traditional joint roommate lease, or am I dealing with a more favorable single roommate lease? And the place that I go is I generally start with the description of the property. Is the property being rented? Is it the entire rental premise? Or is it a room with common areas? That's going to be a telltale sign to me as to whether or not joint liability attaches or whether or not this is a single tenant lease. The second place that I generally like to go is to the signature page. Did one tenant sign this lease or did multiple tenants sign this lease? That's another telltale sign. Now, I'm not saying that those will be fully dispositive, but it's a good starting point for people to look at to try to determine which type of lease they're signing.
Hmm. So So if a student is already in a lease, with a joint and several liability, what proactive steps can help reduce the risk if a roommate becomes unreliable?
So I'm going to say early detection. Early detection is everything. For example, if you see a roommate and they're struggling, right? Struggling with their rental payments. If you get ahead of that, you could come up with some solutions before the rent is not there. Um, the earlier you start strategizing, the more likely you're going to be successful. All right. So early detection, early strategizing. Don't wait for the eviction notice to show up. As soon as you start seeing a problem, you want to get ahead of that. And even if that is terminating the lease and getting out of there before joint and several liability starts to roll on you.
Hmm. So how difficult is it to strategize that lease termination?
So it's actually one of my favorite things to do for tenants. I love strategizing tenants out of unfavorable lease situations. So it's not difficult, in my opinion. It's not difficult. The most difficult thing I would say is um, I will look at the entire situation, and many times I'm going to terminate the lease on a basis that has nothing to do with the problem that's on the table. For example, say for instance, if we have a situation where tenants can't afford the rent and they want out, of course I can't terminate the lease based on your inability to afford the rent. So we're going to go to other areas and we're going to look for other things to help strategize you out. For example, is there a failure to make repairs? Is there mold in the home? Is there a pest issue? Those are the types of things that I would start looking at. Now, I will admit some of my tenants, it's a tough sell to get them to terminate the lease based on something that they're not actively complaining about. So that probably would be the most difficult part of terminating a lease. I may not be able to terminate it for the exact reason you want to terminate it for, but I'm going to advise you to terminate the lease based on a reason that's going to stand up in court or cause the landlord to walk away from the termination and not pursue any further action against you.
So how difficult is it to assign a lease or sublease one's interest to another tenant?
So assignment is definitely one of those solutions that we try to help tenants come up with. Is assigning a lease or subletting, and it can be difficult. It's going to depend on the landlord. Now I'm going to say assignments and subletting is more. More landlords are open to it and student leases and in college towns and college areas, but it's going to primarily depend on the landlord. Some landlords are open to it and make it very easy. Other landlords make it very difficult. But you're going to have to find someone who is going to be satisfactory to the landlord. So it really just depends on the landlord we're working with.
Cool. Okay, Miss Debbie, thank you so much.
My pleasure.
All right, guys. That wraps up today's episode of Renters Rights Radio with attorney Debi Rumph. If you were a student or who are already in a lease and dealing with a roommate who stopped paying, or you want to understand what you're signing before it becomes a problem, visit debirumph.com/lease-termination/options to get strategic guidance tailored to your situation. Don't forget to like, subscribe, and share this episode with someone who might need it or might need to hear it as well. Thank you so much, and we'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.